Problems that we've had living in private rented accommodation is disrepair of the property. We've got mould, damp, pests. We actually had slugs in the kitchen.
At first we tried to contact the landlord and we tried to be reasonable with him and let him know what the problem of the house were, but he did not cooperate, so we had to involve the council.
Now we're in the process of trying to get it fixed, but this is 6 months on that we're still kind of trying to get everything sorted. Living in this accommodation has been horrible and difficult on my course, and obviously on my housemates courses and stuff like that.
You get annoyed with all the problems that's created, and it creates stress and you get frustrated and you just don't want to deal with anything else.
Each year, students choose to live in private accommodation without being aware of the potential dangers of rogue landlords and so fall victim to poor quality living standards and stressful conditions.
Don't let these rogue landlords get away with it. Get to know your rights and what you should be aware of when moving into private accommodation. Such things you should be aware of are
Tenancy agreements,
and how to end them correctly.
illegal eviction and harassment,
Deposit protection schemes and inventory checklists when moving in.
the potential dangers around a property and how to spot them.
And your rights and responsibilities, just to avoid further stresses.
Tenancy agreements can be scary and confusing, but they are essentially an agreement between the landlord and the tenant. A landlord does not have to provide a tenancy agreement, just an address for which to serve papers. If no tenancy agreement is provided, it is assumed that you're in an assured short-hold tenancy lasting for a period of 6 months. If a written agreement is provided, it is important that you read through all the information on the agreement. Before signing your agreement, you should check the type of tenancy. The most common tenancy agreement for students is a fixed-term assured short-hold tenancy agreement. However, this is always worth checking before you sign a tenancy, as your rights and responsibilities can alter depending on the agreement. Your liability. Your agreement may include a clause that if any tenant leaves, the remaining tenants have to find a replacement for the leaving tenant or make up the difference of rent to be paid. Bills. Your landlord may be willing to pay for bills and other expenses which will be included in your rent. However, you must get this in writing to avoid disputes. Charges and rent increases. Additional charges can be added if rent is paid late. It may be possible for a landlord to increase tenants' rent if it says so in the agreement. It is best to seek further advice if this situation arises. If a tenancy agreement says no pets, however the landlord verbally agrees to allow pets in the property, make sure this and any other verbal agreements made are put down in writing.
Ending a tenancy agreement. If you want to leave the property and end the tenancy agreement before the fixed term period has ended, you must inform your landlord. Otherwise, you have to keep in mind that you may be liable to keep paying rent unless a replacement tenant has been found. You may also be liable to pay ongoing rent, even if you've moved out of the property and the tenancy agreement has ended, because a fixed term tenancy becomes a periodic tenancy after the tenancy agreement has ended. To avoid this, you must provide your landlord with written notice that you are going to leave the property. The letter should be dated and should expire on the last day of a tenancy period. The notice period you must give is normally 1 month. However, this depends on the notice period stated on the tenancy agreement. You must also ensure that a handover inspection of the property is carried out before you leave to ensure that the property is in good condition. Otherwise, the landlord can make a claim against you for cleaning, damaging or painting, etc.
A landlord may seek possession proceedings if rent is constantly paid late or you are in rent arrears. However, a landlord must get a court order to evict you from the property. If a court order has not been issued and the locks on the doors have been changed or you're being forcibly removed, you have been illegally evicted and should phone the police and seek further assistance. If you're being harassed, you need to seek further advice. Each case is dealt with on its own merits. However, a comment or action of a racial or sexist nature will be classed as harassment. A landlord tampering with your mail, entering the property without permission, or phoning you without just cause may also be classed as harassment.
If a deposit has been paid, by law, the landlord must use a deposit protection scheme. A deposit protection scheme is a way of safeguarding your deposit and ensuring that it is returned to you once you have left the property, providing that the property is in good condition. The scheme is also a way of resolving any disputes between the tenant and the landlord, and so it is a good way of protecting your deposit overall. There are 4 authorised deposit protection schemes a landlord can choose from. Once the deposit is taken, your landlord must give you the following information: the name and contact details of the scheme, any leaflets that the scheme has supplied regarding how the scheme works, and the procedures for repayment of the deposit at the end of the tenancy. What will happen if either the landlord or the tenant cannot be contacted at the end of the tenancy? What will happen if the landlord and tenant dispute the amount of deposit to be repaid? The details of the scheme's alternative dispute resolution service, the amount of the deposit paid and the address of the property to which the tenancy relates, the name and the contact details of the landlord and the tenant, the circumstances when all or part of the deposit may be retained by the landlord, with reference to the terms of the tenancy. You must also be given a certificate which has to be signed by the landlord to show that the information that they have provided you with is accurate and is best to their knowledge. This certificate must be received within 30 days of signing the tenancy agreement.
An inventory checklist should be completed in the presence of the landlord, and the condition of each item should be noted before the checklist is signed. If an item is not there or is damaged in any way, the checklist should be amended, signed by the tenant, and sent to the landlord by registered mail. A copy of the checklist should be kept for your records.
Fire safety. By law, a landlord is required to provide fire alarms, heat detectors and smoke detectors. However, it is not required for them to provide carbon monoxide detectors, and so it could be in your interest to ask if they would be able to provide one. All landlords are required to have a valid gas safety record for gas equipment in the property they let out. A gas safety check must be carried out every year by a gas safe registered engineer, and a copy of the record must be provided to the tenant. Your landlord is required by law to ensure that the electrical installations in the property are safe when your tenancy begins, and that they are in safe condition throughout the tenancy period. A good landlord should have an electrical inspection carried out by an electrician before a new tenant moves in. If your landlord has done this, they should let you have a copy of the inspection report. If you live in a house in multiple occupation, then your landlord must have the electrical installations of the property checked every 5 years. A periodic inspection report showing that the property continues to be electrically safe must be available. For more information on housing in multiple occupation and whether you are moving into or living in this type of accommodation, visit the shelter website. Energy performance certificates are given to rate how energy efficient a property is. They are almost always required, however, there are a few exceptions and do not need to be provided if a house is not self-contained. For example, if you live in a shared house and share a bathroom and kitchen with other tenants.
A landlord should give you reasonable notice in writing before entering the property you are renting. Reasonable notice is usually 24 hours. If reasonable notice is not given, you are within your rights to deny the landlord access to the property.
Disrepair is when the property has suffered deterioration regarding Section 11 in the Landlord and Tenants Act 1985. The landlord must maintain the structure and exterior of the property, including drains, gutters and external pipes. The installations in the property for the supply of water, gas, electricity and sanitation. The installation of space heating and water heating in the property. The landlord may have other repair obligations if stated in the tenancy agreement.
It is not advised that you withhold rent even if the property is in a bad state of repair, as the landlord could issue possession proceedings due to rent arrears, meaning you could be evicted from the property. If you refuse to pay rent, it is also possible for the landlord to pursue legal proceedings to redeem the rent you haven't paid. If you're thinking of living in private accommodation and want to find out more information, go to shelter.org.uk. Or if you're currently in a difficult situation with your landlord or with the property you are living in, visit your local Citizens Advice Bureau.